you need to have a standard contract. And that standard contract covers everything that you will do in the business. And what the standard contract does, it says, this is how it is if you want to work with me. So that all you have to do is fill in the particular terms for the person that you're working with. So for example, let's say that you are a coach and you are going to be working with, I don't know, a financial planner. I'm just totally making this up. You're a life coach. You're working with a financial planner that's going to provide services to your coachee. You will have an independent contractor arrangement with that financial planner instead of putting them directly in contact with your coachee. You will have a standard contract that says what that agreement means. Certain things that you definitely have to have in there is who's going to do what are the deliverables, what state law is going to govern what you guys are going to do, whether or not, if there's a dispute, how the dispute is going to be handled. And what I mean is, yeah, everything is great once you guys come up with this great plan of how you're going to work together. But what happens if things go sour? That's what you need to agree to up front. If I'm in Alabama and you're in, let's say, North Carolina, well, whose law is going to prevail? What I always tell my clients is that always use the law that is most favorable to you. Now, that doesn't mean if you're in North Carolina and I'm in Alabama that you can use Delaware. It's not that type of party. It all is going to be governed by the parties to the contract. So, for example, when I have standard contracts, I think people just kind of know, like, the standard part is almost non-negotiable. We go into arbitration after mediation. You're not suing me. And if you do something in that scenario, I was always have an indemnification clause. If that financial planner does something that the client does not like or that causes the client harm, your independent contractor needs to indemnify you, which means that that client cannot come back and sue you for something or an error or omission of the financial planner. You must have that in the contract. If it is not in the contract, you are open to be sued. This is one of the major areas that my entrepreneurs never, ever think about, because they're just thinking about services. They're not thinking about the liability side of it. It is crucial. If you are an independent contractor, if you are a coach, especially if you are a coach or any type of counselor, you must have errors and omission insurance. You need to have some liability insurance. And the thing is, a lot of industries like the legal industry, like the financial industry that Saafir is in, you're required to have it for licensing purposes. So you're just automatically prepared. But the average person isn't. I know people, they work with people all the time. They're telling them, oh, you can do this and you can grow your business and you can do that. They have nothing in place to protect them if it doesn't work. So again, you need to have that. But again, in your contract, you need to also have a clause in there that says, listen, this isn't a guarantee. Even if you do everything I tell you to do, it doesn't mean that you're going to have the results that I've had, the results that other people have had. That is crucial. That is very, very, very important. And again, all of those are handled in independent contracts. Now, on the other side, if you are the receiver of a contract, so for example, a lot of you guys are speakers, so people will give you contracts to come and speak. You need to look at well, first of all, some of you may not even have contracts. Let me say that, because oftentimes people have you coming somewhere. They'll say, oh, we're going to have you, and they're promoting it and all this sort of stuff. And you have no contract in place, no guarantee. You guys have just kind of talked about how you're going to do the money. Never do that. Always ask, even if you're speaking for free, always ask, do you have a standard contract? If the person says that they don't have a contract, you need to have one yourself that you send out. Because there's an exchange, even if it's not money. Typically, it's marketing. Typically, it's you come and speak. So this kind of leads me into a second area that I want to discuss. So let's say we have that scenario and you're a speaker and you're at an event and they're recording the event, what happens to that information? Who owns that information? Who owns your information that you're giving out? Who actually owns that? I'm asking the question, like, who owns it? Because that's the stuff that you need to have in your contract. That's why you need to have your standard contract. Someone told me that it happened. I ain't gonna say the who, but that's what happens. Because let me tell you something. A lot of conferences are very good about this, because, and I'll let Audrey speak to this afterwards. With one video, and I learned this directly from Audrey, so I'm gonna toot her horn too. Off of one video, there are at least 5 money-making products that people can take and sell just by repurposing what you have brought to the table. You need to have that up front. So if they don't have a contract, you need to have one. Yeah, I'm speaking for free. However, I own the information. And if you in any way distribute that information, this is the cut that I want. So that if 10 years from now, you see it on Audible, you see it on a DVD, or you see it on some movie, pay-per-view, now you have already up front said, I want an interest. So if you have to present that in court, now you have a breach of contract situation where you go to court and you demand your cut. You may not even have to do that. You may just call me or an attorney in your state and let us send a letter saying, I really need my cut. I need my royalties. So what I'm saying is, these are all the hidden things that we don't think about. I remember, I'm a lawyer. I remember years ago when I first started speaking, I would just be happy that somebody wanted to listen to me. I was everywhere. Like, I was all over the place. I was at this conference and at that. Oh yeah, listen to me. Until somebody sold the DVD. And I was like, oh no. But see, really, to be honest, what recourse did I really have? Because I had not agreed up front one way or the other. It ended up not being financially really reasonable for me to go after it. But what I said was, oh, wait a minute. I had to look at myself as the client. And so when I thought about it, if I would have had a client come to me and say, well, I'm doing this, these were all the things that I would have said. But because it was me and I was so excited and it was something new, I didn't even think about it. And so that's part of my motivation for sharing this with you guys, is to always have a standard contract. If you got your standard contract from LegalZoom, FindLaw, onlinelawyer.com, or any of those, beware. If you got it from Office Depot, Staples, Office Max, Walmart, Sam's, beware. Because more likely than not, one, they probably are technically legally sufficient, but all of your bases will not be covered. They're general contracts. Every contract needs to be tailored to a specific situation. So there's a plus and a minus to that. The plus side is, do you have a legally viable contract? Maybe so. The downside of it is that, unfortunately, there's no recourse. When you either sign one or you give one, you're stuck with whatever's in that contract. And I will tell you that when you have a contract like that again is one of these form contracts, under the law, they will consider that you, the person that gave the contract, you're the drafter. And the reason that is important is because under the law, if you draft a contract and you put all the terms down and you control all the terms, and you say, well, we don't negotiate all of the terms, we just negotiate certain things like duties and responsibilities or payment. Well, those are always going to be negotiable terms. When you do that, any deficiency in that contract, now this is as a matter of law, any deficiency in that contract, the judge is going to find against you, because you were in total control of the contract. So if there's something in these standard contracts that is not in your best interest, you're just going to have to eat it. That is the major pitfall of getting contracts online. It's the major pitfall. Even if you got a contract and you say, oh, well, this works fine. If nothing else, pay an attorney $200 or $300 to do a legal review for you, to add to that contract that you love and you think it's just so phenomenal and you haven't had any trouble. Because let me tell you something, all contracts are great until you get sued. I mean, it's fabulous. You have a paper that has been signed by the other party, and guess what? Everything is fabulous. Either until you get sued or until you don't get paid. Because when you don't get paid or you get sued, you will see all of the deficiencies in that contract. So one last thing, again, in addition to when I was talking about who owns the content, again, Audrey is the content queen. But when we talk about ownership in content, you have copyrights, you have some trademarking things that, you may have something proprietary that you're sharing. I know a lot of speakers, they're therapists, they're counselors, and they may have a way that they do some type of therapy that other people don't. So now you're out at this speaking engagement and you're telling other people how to do this and you're teaching other people how to do this. So have you taken any steps to protect that? Have you taken any steps to protect your thought leadership? You have to think about all of those things. Just because you wrote a book about it doesn't mean that it's protected under the law. So these are all the points. Again, there are thousands of questions, but based on what we talked about tonight, I think, based on what we talked about tonight, those are the points that I definitely wanted to hit, in addition to the things that I've shared previously with you guys, because I think it's very important. The people that you need to have on your team, you definitely need a CPA. You definitely need an attorney. You need a person that can help you understand how to maximize all of your content, a video marketing person like Audrey. We all need somebody that knows about credit, both for personal and business reasons. And this is why I wanted to pull this team together, because when we're looking at entrepreneurship, these are the entities that you need in the team. So I have one, let me see, I have a question. Okay, I'll just read it. It says, some guests likely need all of our services, guys, but it can be overwhelming when you think about maybe you can't afford everybody's services at this time. And so let me speak to that, and then I'll let everybody else talk about it. So just to ease the minds of the small business or the solopreneur, because I have people tell me this all the time. I don't have an attorney or I don't have a CPA because I can't afford it. Let me say this. You can't afford not to have access to one. And what I mean by that is, if you build a relationship with someone like Saafir and you build a relationship with someone like me, it may not be where we require you to have us on retainer. Again, depending on the nature of the relationship. Now, for me, what I do for businesses is, when I was talking about standard contracts and things like that, anyone that comes with that works with me, I provide all of that, of course, for a fee, but I provide everything that you need. So the only time that you need to come back to me after I prepare those initial documents for you is if there's a question. So let's take the independent contractor agreement, just because I mentioned that. I will prepare your standard independent contractor agreement, and I will give you a checklist of every single thing that you need to discuss with the other party and the information that you need to get and how to put that information in the contract. You prepare that yourself, and then you can send it back to me for just a final review. Again, there is a cost for that, but for a final review before you provide that final draft to the other person. Now, what's the cost for that? Hey, It depends, because it depends on how intricate the contract is. But I will say it's anywhere between $250 and $750. But you only pay that one